Hi, in this presentation we will discuss about inequitable conduct during patent prosecution or fraudulent procurement of patent. Inequitable conduct is an offense against patent office and public. Inequitable conduct offense is committed by patentee most commonly by intentional failure to submit material reference or material prior art reference which was important for patent examination during patent prosecution, or misrepresentation of material facts to the examiner, or by making knowingly false or misleading statements to examiner during patent prosecution, and all of which was coupled with intent to deceive the examiner in order to get the patent grant, and on which examiner justifiably relied in granting patent, but for which misrepresentation or deliberate omission of material reference or material prior art reference, patent would not have been granted. If this important material information or material prior art information was submitted by patentee during patent examination, examiner might have or would have rejected the patent. So by deceitful intent, patent prosecution process was subverted. If all of this is proved, then inequitable conduct will be proved. And if inequitable conduct is proved, then it is a good defense in infringement also. The infringer can assert the inequitable conduct in infringement proceedings in court. But in order to prove inequitable conduct, knowing of willful fraud or inequitable conduct by patentee must be shown, which is predicate to the potential antitrust violation. Ultimate determination of inequitable conduct is committed to trial judge's discretion. The judge will decide on inequitable conduct, and inequitable conduct decision is reviewable under abuse of discretion standard. So patent procured by fraud or inequitable conduct will make patent unenforceable permanently. It will not be enforceable if inequitable conduct is proved in court. Now, avoiding inequitable conduct. There was a change in 2012. Since September 16, 2012, patent owners can now request for a supplemental examination of their patent by USPTO for purpose of correcting, considering, or reconsidering the information which was omitted during the initial first examination. which was not submitted during the first examination. Now, patentee can submit this material information or material prior art reference and can request for supplemental examination after submitting this omitted information, which may be relevant to patent in question. So now supplemental examination can be requested by patentee after submitting this omitted material information which was omitted in the first examination. Now if this supplemental examination request is accepted and supplemental examination is conducted by examiner, then examiner may either confirm the validity of patent even in light of this submitted information, or examiner may reject the patent grant based on this information which is submitted now and not submitted earlier in the first examination. So if validity of patent is confirmed even in light of this newly submitted information which was omitted in earlier examination or first examination, if the validity is confirmed, validity of patent grant is confirmed by examiner, then the infringer or anybody now cannot use this information which was omitted earlier in the first examination for proving inequitable conduct. So if validity of patent grant is confirmed in light of this newly submitted information which was omitted in the earlier first examination, then infringer or anybody cannot use this information which is now submitted for proving inequitable conduct. So that's all in this presentation. Thank you very much.